Up next is Harry Sutton from University of Colorado and affiliate faculty here again at CodeX. If the morning was table setting, we're going to get an example out of one small area. We really want to think about a large area, so we acknowledge that this is one leg of a many-leg table. Maybe that's not the right metaphor, but Harry's going to let me have it. Anyway, Harry Sutton, thank you.
Thank you so much. And thanks for that introduction. As you said, I'm Harry Sutton. I'm a professor at law at the University of Colorado Law School and also affiliated faculty here at Stanford's CodeX Center. And as I mentioned, my research is in artificial intelligence and law. So before I begin, I want to thank all the people, again, who worked so hard to put this together, particularly Oliver Goodenough, Susan Salkind, Roland Vogel, and CodeX and the Stanford Law Program Group, Rebecca Purdom, Mark Flood, Mary Beth Dewey, Meng Wang, and the Kauffman Foundation, and all the others. We've been working for months to put this together, so I really appreciated everyone who helped organize this. So today I'm going to talk about a vision for computable contracts, a project I'm going to talk about in more depth. Has been mentioned, this project aims to develop a general protocol for expressing law computably, and the one subtopic we are picking is the area of law, computable contracts. So we'd like to express this vision of a protocol and a standard and a suite, importantly, a suite of high-quality open-source software tools to enable this. But let me just say a little bit about this vision, then I'm going to go into the details and come back up so we understand what's going on. This computable contract protocol aims to be open source, flexible, extensible, and compatible with existing technologies such as the blockchain, but I want it to be extensible to new yet undeveloped technologies. So as we're saying, contracting is just one area of law. There are many other areas of law, as you know, and the hope is that the ideas developed here in the context of contracting and making contracting computable will be extensible to other areas such as computable regulation, computable legislation. So the lessons learned, we hope, will be transferable outwards. I want to emphasize at the outset, this is just a vision, a starting point for the discussion. I'm not suggesting that my ideas need be implemented at all or in part. I'm just trying to spark a conversation, and I'm open to moving any and all different directions. So this is be the outline of my talk here. We're going to talk about what are computable contracts, provide some definitions. I'm going to provide a vision. What would the world be like with computable contracts? What is missing today? Importantly, I don't think we have all the pieces of the puzzle. I'm going to give a proposal that I call the computable contract stack and kind of lay out that idea. And then we're going to have a group discussion, and I invite you to respond not just to my talk, but all the previous talks that we have just had in the last hour, Oliver, Mary Beth's, Susan, and Mark's. So let us dive right in. Let's start out by saying, what are computable contracts? Some basic definitions. So for the non-lawyers in the room, you might not have thought about the definition of a contract, but a contract is a legally enforceable promise to do something in the future under certain conditions. So here we have a very simplified version of a financial option contract. I promise to sell you 100 shares of Apple stock at $200 per share prior to the expiration date of August 12th, 2017. So we've got our terms, which are what you're bargaining about, 100 shares of Apple stock and the quantity and the price, and the conditions. Only before the expiration date will this be valid. And then usually a contract is an agreement to transfer some asset, a good or service or a right, in exchange for payment. That's your traditional contract. What is a computable contract? A computable contract are legal contracts that computers can understand, assess for compliance with the conditions, and execute. So one way of thinking about it is a computable contract is a contract where the terms and conditions are expressed as data, and along with the data come a series of rules that tell the contract how to effectuate or handle the terms and conditions in a way that logically represents what the parties are actually contracting about. So we're going to see what that means in a second. And I say understand in quotes because, as those of you know, the computer doesn't really understand what the contract is about. We give it a means to understand what the contract is about. All right, so the best way to understand computable contracts is by contrast to the way we have ordinary contracts, your typical contract that we all deal with on a day-to-day basis and that lawyers draw up. Your typical English language contract is what computer scientists would call a natural language contract, natural language being the computer science word for the ordinary spoken and written language that humans use. Unfortunately, computers have very limited ability to analyze natural language contracts, such as I promise to sell you 100 shares of Apple stock at $200. Given today's technology, there's just too much variability in the way in which natural language can be expressed for computers to reliably assess it at the level of specificity and accuracy that we would need to determine contract compliance. So a different approach to expressing English language contracts is to instead express computable contracts. Now, computable contracts are both machine readable and computable. And I think it's really important to make this distinction between machine readable and computable so people understand the difference. So there's been a lot of work on machine readable contracts, but that is a different thing from being computable. So machine readable contracts are useful and great, but these are essentially contracts whose individual components have been labeled in a highly structured way that a computer can parse or identify the components. So, and these are often associated with standards such as XML for marking up or identifying the various components of a contract or some piece of data. So for example, the natural language version of the contract dealing with an expiration date might say, this contract expires and so no longer be valid after August 12th. A computer couldn't easily parse that. Why? Because you could express that same idea in different language. After the 12th of August in the year 2017, the contract shall no longer be enforceable. So the computer would have a tough time with this in two ways. Number one, it wouldn't know that English language expression is an expiration date, right? Because it wouldn't be able to recognize it. And number two, it wouldn't easily be able to pull out the date, August 12th, 2017. So the reason we make things machine readable is to provide a highly standardized, structured format so that we can mark up data so computers can unambiguously identify things such as expiration dates and then pull out the data unambiguously. They can pull out the month, the date, and the year, which they have a hard time doing today. Of course, in order to do that, you have to agree on a standardized label for the data, like expiration date. So this is kind of a oversimplified version. But once something has been expressed in highly structured form in a pattern that the computer knows about, the computer can unambiguously extract the data. Once the computer knows to look for that pattern of expiration date, it can look for that label and then pull out the data, and it won't have a problem. So that's machine readable, and there's been a lot of work in making things machine readable, taking an English language contract, labeling all the different parts, and allowing us to pull out the data. That is not computable. Why? Because the computer doesn't know what to do with the word expiration date. The computer doesn't know what an expiration date is. When it encounters that label, it has no idea what to do. So that's where computable contracts come in. Computable contracts are both machine readable and computable is essentially giving the computer a series of instructions and rules to allow it to know what to do. For example, if you wanted to make the contract term expiration date computable, you'd give the computer a series of rules that mimic the underlying logic of what an expiration date is. So informally, we think of an expiration date as after this date, the contract is no longer valid. So you want to kind of replicate that logic using computer rules. So here I have a very simple representation of what an expiration date might be that's computable. You say to the computer, hey, if the current date is later than the expiration date, don't execute the contract. Right? So now the computer knows what an expiration date is. And how does it know? It knows because you've told it. Right? And there are vastly more complicated ways that the computer can know these things. So I've just provided a much oversimplified way. There are all sorts of ways that you can inform the computer. But that's essentially the gist. So a computable contract is both machine readable, so the computer can pull out the individual components, the expiration date, and the month, date, and year, and computable. It knows what to do as a series of rules or instructions to do something about the expiration date that allow it to automate on its own and effectuate the meaning of whatever contract term or condition. All right, so do we have computable contracts today? We most certainly do, as Oliver and Mark suggested. We have limited, what I think are limited computable contracts, but they certainly exist all over the place. At least since the 1970s, we've had electronic purchasing agreements that were some degree computable. We have blockchain smart contracts, which we'll talk about, which I think implement some, but not all, the vision of what you need for computable contracts. To some degree, some of the things that go on Amazon, when you purchase something on Amazon, has degrees of computability in it. But what we have today does not represent the full range of functionality that I personally think we need, but I'm open to hearing what you guys think as well, of course. But before we get to that, let's talk about a vision of a world with computable contracts. Why is this a worthy enterprise? Why do we want to be doing this in the first place? So if our goal is to create a standard protocol, a stack, an ecosystem, and a series of open source tools, why are we doing this? At least my vision is to make computable contracting nearly effortless. Right? So the vision is to see a company or a person sit down at the computer, and for any arbitrary goods or service purchase, they easily execute a computable contract that gets accepted and is legally valid throughout the business ecosystem. You can't do that today, and that's the gist of the problem in ways that I will describe. But I think there will be many benefits to computable contracts, although some risks, as Mark suggested. But the benefits are obviously the lower legal costs. A lot of contracting today is bespoke, where lawyers charge hundreds of dollars an hour for document assembly. There's certainly efficiency and cost reduction, both in terms of creating contracts and also assessing compliance with contract terms and monitoring contract compliance. I think there will be lower barriers to entry for entrepreneurs if you can make computable term sheets or things of that nature. A lot of startup documents, although they look very complex, are actually, most contracts or many contracts boil down to just a few key terms and conditions. So if you were to look at your typical contract, which is 40 pages long, and you said, what are the 4 most important parts? Most lawyers could pick out 4 things out of a 40-page contract, and the other 39 pages are sort of what might happen when Hurricane Irma descends in the middle of our contract. One real interesting benefit, and this relates to Mark's point, is that once contracts are expressed as data and rules, they can be inputs to other computer systems. And I think this is one of the biggest benefits. So for instance, say we're trying to avoid the next financial crisis, and we want to know how much risks are banks carrying on their books. Today, you have to pour through millions of pages of English language documents trying to figure out who owes what to who's the counterparty, who are the intermediaries, what have settled, what's the value, right? If these things are expressed as data and rules, you can input these systems to other systems whose job it is to understand this, and you can basically compute the risk much easier. There's all other things you can do is detect contradictions. If you promise the same good to 2 different people, this happens in big companies where they have a hard time keeping track of inventory because their contracts are written in English language, but their computer systems are sending goods and services electronically. So there are lots of benefits once contracts are expressed as data. All right, so what don't we have today? Why aren't smart contracts the whole deal? I think there's a couple of reasons. So first I want to acknowledge all the hard work of a lot of people in this room. I think we do have a lot of the puzzle pieces today. We have a lot of bits and pieces. I think the blockchain can be part of the puzzle, smart contracts. A lot of the work done by the pioneers in this room really are part of the puzzle. But I don't think we have the whole puzzle, and that's why I think we're here. We do not have a full-scale solution for computable contracts from A to Z today. Today it's not easy for one person to sit down at a computer and just seamlessly execute a computable contract. We don't have the infrastructure, we don't have the open source softwares, we don't have standard computable. Today we do see computable contracts, say in finance, but it took them over 10 years and hundreds of millions of dollars of agreements and standardization to get that. So the barriers to entry are very high. So today we have an absence of standards. We do have a lot of activity going on, but largely these are domain specific. So we have activity going on in the finance industry, R3 around blockchain, that's very interesting. We have things surrounding Ethereum and initial coin offerings. So there's lots of bits and pieces going on there, but by and large, these are not general approaches to contracting. You can't contract over an arbitrary good or service with arbitrary terms and conditions, which is what we want. We definitely don't have high quality, visually appealing, easy to use software tools out there. You have some proprietary software tools, but you don't have free open source available tools that will allow people to execute these. Often these approaches are tied to specific technological implementations, so they're tied to the blockchain and not ledgering as a functionality. I think there's it's insufficient interdisciplinarity, and I think this is a big problem. A lot of these approaches have been developed by technologists without lawyers and businessmen, or businessmen without technologists and lawyers, or by lawyers without technologists and businessmen. We want to bring everybody in, also the humanities, the social sciences. I think this should be an interdisciplinary effort all across the board. And then finally, as Oliver said, there's insufficient ecosystem and buy-in, right? So if you build it, they will not necessarily come. You need to build it and make them come. All right, so I'm throwing out just one suggested architecture. Again, I'm just hoping to open the conversation. I don't think we necessarily have to do this. And this is the computable contract stack. And when I use the word stack, I mean it as an analogy to the TCP/IP stack, which is, for those of you who know, is a set of protocols that underlie the internet. And one of the interesting things I like about the TCP/IP stack is that it has layers upon layers of functionality, and each of those layers is specified in what that layer has to do. So like one layer's job is to get some data from point A to point B, and that's all it has to do. Another layer's job is to make sure that everything is there the way it should have been. But each layer doesn't have to know how the other layer works, and each layer is technologically independent, which means you can implement it in a multitude of different ways as long as it meets the standards and the specification. So that's a stack, thinking about a functional description of something where things are independent from one another. That's what I'd like to do for contracting. If you think of contracting, there's a series of functions that happen when you're contracting. From the very early beginnings, you figure what you're contracting about, the good or service, you figure out the terms and conditions, maybe you negotiate, you transmit your offer, somebody accepts the offer, the contract gets recorded somewhere, then you have some terms and conditions, and then somebody has to perform the contract. Somebody has to perform typically a payment, the other party has to deliver the good or service or asset or right as promised. Then there's some sort of transfer of ownership, there's recording of the contract, there's notifications, etc. So that is not at all the things that go on in contracting. I'm vastly oversimplifying, but that's the general idea of a functionally oriented stack. So this is sort of a general proposal for a similar contract-oriented stack. I eliminated a lot of steps in here, so if you see your favorite component, such as privacy or security, it's not in there. That's important. I just didn't want to clutter this thing up, but let me just quickly walk through the idea behind this. At the top, we have some sort of user interface. I think this is really key. The user interface is what allows the information from the human to be captured in structured form. So right now, the user interface for most contracts is Microsoft Word, or God forbid, WordPerfect in some law firms. These days, that allows for free-form natural text, but it doesn't structure it in any way. So think about the way financial contracting happens for today's computable contracts. A financial trader makes a trade, but they don't realize they're trading, they're making a contract. They do it through a computer program where they fill in little boxes, and by putting information in a particular box, that creates structured data with some meaning. So you need some sort of controlled interface where if you're buying a car or a term sheet or what have you, you're inputting the data in a certain way such that you unambiguously know what that data is and the set of rules around that. The link between that next is a human understandable contract. Contracts so far are ultimately between humans. Even corporations are made up of humans. So in some way there has to be a link between the contract expresses data and a contract that makes sense to a person, whether it's a judge or an attorney or just ordinary person. That doesn't have to be actual English language. So right now, you could imagine translating some sort of data to English, but it could be a visual representation like Mark and Oliver have showed, as long as it has the key components there. So you need some sort of link. Of course, you need a link between the computer understandable, the human understandable, and the machine readable, right? So you need some sort of link between the idea of an expiration date and the standard tags for expiration date. And then kind of the heart of all of this is what I'm referring to quite verbosely as the Standard Contract Transmission Protocol. All that is what a lot of us think about in computable contracts, which is you have a contract that you want to express computationally. How do you do it? What's the language? What's the expressive ability? And here, I think this is really important. The goal is not to be tied to any specific implementation or language. So I want you to be able to express your contract in any language that suits your needs, whether it's Python or Prolog or Ethereum or any sort of language that meets the basic strictures. So with that, we want to have some sort of API, some sort of bridging mechanism between the underlying way you're specifying it and the higher level representation. And I think that's the real value of a stack, which is giving sort of high-level conceptual meaning to your structure of your contract, what you are contracting about, without tying it to any particular language or implementation. And that's what I think makes it more flexible and more likely to be adopted. Because if you go to somebody and say, you have to use our particular language, you can't use worksheets, you have to use Python, you can't use JavaScript, that I think is going to doom the effort. So that's sort of the heart on the side. These are all the layers making you specify your contract abstractly, and then you have some bridging layers which allow you to express those in any particular formalism that you so desire. And then finally, we have the contract functionality. And again, these are, what do you do in a contract? Well, you do different things. You store your contract. You notify when terms have been complied with or not have been complied with. You determine compliance. This is, you record your contract. You record transferred assets. You sign it. So things like the blockchain perform some of these functions, but they don't perform all of them. You know, the blockchain is really good about storing assets and asset transfers and digital signatures that can be verified, but they don't have all these other elements here. And importantly, I want this to be, or I would suggest that this be not tied to particular technologies, right? So you could use the blockchain for ledgering, keeping track of ownership and offer and acceptance, but I don't think you should be tied to the blockchain. You could use an ordinary database or Amazon Web Services to perform the ledgering function. So I think that we should think of these conceptually as what you need to do when you're contracting, and that can be implemented in any one of particular technologies, whether it's the blockchain or it's your ordinary database. And in that way, we sort of get freed from this technological dependence to some degree. Another idea is to have templates. You don't want to reinvent the wheel every single time. And there are a lot of common transactions that happen all the time. This is exemplified in finance. They have these templates for options contracts and things like that. So I think part of this project should be developing a series of templates for very common contracts, things like, you know, term sheets or things of that nature, or purchasing a car, what have you, that people can just take off the shelf. And then finally, not every contract has to be computable. I want to make this point. So I think this kind of frees us if we think, oh no, we've got a merger agreement between Merck and another pharmaceutical company. How are we going to express that 500-page merger agreement computably? I don't think we have to. There's still going to be a room for bespoke English language contracts. And there's still going to be a lot of those, but that doesn't mean there aren't a lot of standardized contracts that can be made computable. So just because we can and should not make a whole bunch of contracts that are complex computable doesn't mean we can't make a whole bunch that are standardized and repeating computable. And I think once we give up the dream of trying to make every single, that's my I think it's open for discussion, of course, but my inclination is try to make computable what it makes sense to be computable and leave the rest alone, at least for the moment. But I'd love to hear other thoughts. And then finally, I'll just say, again, computable contracts are just meant to be a starting point. We picked this because contracting is private lawmaking, so you don't have to rely on Congress to use these tools to do contracting. Rather, we have individual people who can voluntarily opt to use these tools to capture their data electronically, and we can learn lessons from actually implementing it. And I think these lessons can be extended more broadly to computable legislation and regulation. So I will stop there and open it up for discussion for all of the talks, not just mine. So thank you.
Thank you. Wait, I got one of these. Did that work? Awesome. Am I okay? Look at the gal at the back. So we did want to have a conversation across all of the talks. We had thought about starting earlier and having conversation, but we thought it was a good time to have this conversation as a whole. And I'm going to keep Harry up here with me. Am I okay? I'm feeling loud.
You know, I think
he's adjusting me.
Yeah,
okay. Oh, that's much better. We're going to have this conversation as a whole, but we have a couple of tasks to do before we go to lunch. This is, you've listened to a lot, now you get to actually work before you get to eat. One of the conversations that we started with Harry is about contracts, but of course this conversation is supposed to be much, much larger. And so we want to talk about a few things. We want to talk, are you going to, we want to talk about, we want to talk about some definitions that we can use throughout the conversation as we think large. And we want to talk about what exists now and what the limitations on existing technologies might be. That's the start of our conversation. I'm going to ask Ari to start us off as we get set up here. We talk about definitions, and you use the magic word stack. Stack means different things to different people. Can you just talk about that for a minute?
Yeah, so the idea behind the stack is to talk about contracting from a functional sense, rather, so what are the different activities we do from soup to nuts, from A to Z when we're contracting. So it's sort of an abstract view of contracting, which we can then implement technologically. And the other aspect of a stack is that it's independent of both the different layers. So for instance, the layer that does the notification doesn't about whether or not you met the contract terms, doesn't have to know or care about what else is going on or the different layers or how your contract was implemented. And also the notification layer or the recording ledger just has to fulfill certain functions. It doesn't have to do it in any particular way or using any particular technology. So that's the general idea of the stack as I use it, but I'm open to other terminology if that's confusing.
So that's where I'd like to start, is that's Harry's stack, and we leave Harry with Harry's stack. But I'm curious if other people in the room have a different definition for the word stack. Yes, sir.
Jeff Braswell talking about, I want to commend you on your use of the analogy conceptually of a stack, but just in the concept of the communications protocol as opposed to the component of the software stack, most of the work that will be done in interpretation of meaning is not at the transport layer, it's at the application layer. So the transport just delivers a packet with an envelope to a destination. That's really what TCP/IP does. But the application layer and the session layer has to understand the meaning. So I really would say that there are two basic levels in your stack. One is the encoding of meaning and rules at a higher level. And then the definition of those things that can be machine translatable and communicable via messaging and through unpacking of that. So I just think that the analogy of the stack is good conceptually, but I would suggest that if you're using the TCP/IP concept, there can be some refinements that probably would be quite useful, because in fact, it's the higher levels of meaning that really make the challenge more difficult with the legal interpretation of execution, whereas it's easier to define certain terms and glossaries in a data dictionary at an XML level. But that's really my main contribution on your stack concept.
Yeah, great. Well, thank you. So yeah, thank you for that. I'll just say that the stack, that's just a very open way to start the conversation. So it's certainly open to refinements such as yours.
The only thing I would add is that there's also the talk of stack meaning software stacks.
Right.
You've got components that do different functions.
Correct.
So I think you're talking a little bit more about a functional composition of a block diagram of
Yeah, I think more a little amalgam of both, I would say.
Yes.
Yeah.
So you'll notice that we've been asked to put the mic in the middle of the room so that we can have folks line up for it so that it works. One moment.
Let us know when you want to take questions from the remote.
We're going to let the folks on the remote know we're going to get to them in about 15 minutes, and we will make time for them then. Thank you for reminding me.
Could you
sir.
pull your stack slide up again? Yeah. Oh, anyway, if you could just hold it in your mind
Yeah,
instead.
okay.
So like Jefferson, I had similar feedback on the question. I'm glad you're asking about the stack, because it's one thing to put it out there to stimulate discussion, but if we want to maybe use a stack, we should talk about it. So something that I noticed, I would add something to what Jefferson said, where he kind of broke it down to two basic collapsed layers of more or less transport and a bunch of network stuff at the bottom, and then application layer where a lot of logic's happening. I think you correctly, though, have the third huge layer for legal, which is the interface layer, where a lot of the meaning is processed in the minds of people. And what was displayed is legally significant frequently if you have to create and preserve evidence of what someone saw and reconstruct other more subtle things. So that interface layer, like in the NSI layer stack, is a big one for us. But to go deeper for a moment, I think there's another unique property of the type of electronic object that is a contract that isn't necessarily captured with the transmission protocol you said, and it's that we share an object. So the piece of paper, when it's instantiated in atoms, that's not too hard. But when it's instantiated in bits, and we know that we've come to agreement on the same thing, and especially for the subset of objects that are contracts that are also bearer instruments, or negotiable instruments, transferable records, or otherwise for some reason it's important to know which the authoritative one is, that's big. But the main thing is if we want to stay in sync, if we want to know when amendments are, if we want to manage this digital resource, there's another thing down in a network layer of discoverability and might be object, I don't know, people here would probably know better, but there's something about the oneness of the contract so that it's a resource shared on a network. And also identity is probably we'll probably need to get more sophisticated with breaking down capabilities and functions and stuff like that.
That's great, great point, thank you.
Would you say that the bearer instruments are particularly amenable for blockchain context, whereas other instruments are more suitable for Amazon Web Services?
Yeah, could you just explain what that means, Charles?
Well, the reason I thought that was because in the blockchain context you have the decentralization and objectivity and persistence of the record.
Uniqueness of a digital asset.
Okay. Great.
I'm going to remind folks that we have 20 some odd people online, so we really do need to use the mics. I know it's nice to have the impulse to talk, but let's make sure we get mics to folks.
All right.
No, it's okay. Yes,
Hi.
sir.
When I think about contracts with anyone, anywhere, for more or less arbitrary things, I think a lot of us already have that in our lives with, say, Amazon or with eBay, right? I go on Amazon, sure, I buy a lot of stuff from Amazon itself, but then there are a lot of other third-party contractors who I buy stuff from, and I don't have to think about any of it. 2 clicks, I'm done. I trust that Amazon's then going to work out the arbitration afterwards if we have any problems, and I'm pretty satisfied with all the stuff that keeps arriving at my door from all these different contracts. I wonder if you have some thoughts about, maybe it's a repeatable contract if it's not computable. It's the same contract that we all sort of trust is going to go on for all these different items.
Yeah, I think that's a great point. And one of the things I'd like to talk about in the working group is maybe we have all or most of this today and we don't need this. So one of the things Meng is going to talk about this a little bit later, like surveying the landscape, and maybe we just need to build components or on top of what we have today. So I welcome those types. Right.
So if we've had this conversation about the stack and we recognize these different layers, these different needs, I think Oliver wants us here for one particular piece, which is this protocol language, the way in which, the way in which we're going to have this conversation. So I want to get to that definition in a minute. Think about that.
I just wanted to raise the thought that we learned from the Dow incident in Ethereum, where if you have a situation where the computable contract is a complete process within itself, and then something does go wrong, do you live with the complete process, or is there a part of the layer which is to shoot it out to some sort of judicial or other sort of conflict resolution part?
Yeah, that's a great question. I think a good model, maybe Charles, I don't know if you want to speak about, is the ISDA model, where where they have sort of an English language master agreement which governs when things go wrong on top of a bunch of computable agreements. So
I think what you said is enough. And
yeah, right. So there are different ways to deal with this. They do have sort of mechanism, and it's something we need to think about, I think. So in finance, there's something called the ISDA, which is kind of an agreement between a bunch of large financial institutions who trade with each other, dealing with trading, basically data-oriented securities and clearing, and what happens when somebody does a fat finger mistake and orders 10 million Apple shares instead of 1, that sort of thing, and how those things get adjudicated. So a bunch of, maybe 10 or 15 years ago, a bunch of financial firms got together in a room, hammered this out, and said, we have these data standards. When something goes wrong, this is the master agreement we fall back on to deal with that. So, yeah.
I have 2 here.
Folks in the queue, and then we'll come back over this side.
So Harry, just picking up on something else that you mentioned about that, not everything necessarily needs to be a computable contract, but just to interject into this discussion, the idea that, sure, a 500-page purchase agreement, we may not be thinking about the opportunities there, but we should be thinking about the opportunities there. And I think this is a common problem across this space when we think about automation, and the lawyers pushing back and saying, what I do is too complex, you can't automate it, you can't break it down. There's a tremendous need for the lawyers to be doing that process work, improving traditional contracting processes, thinking about maybe not the whole 500-page agreement is going to be computable, but components of it. And you think about holdback disputes, escrow disputes, all kinds of things that lawyers should be thinking about. How can I turn that into a computable contract?
Yeah, that's a great point. I think that's a larger theme we should discuss in the working groups. You know, how to integrate English language or natural language contracts with computable components, how that all works together. For example, if Mark Flood in the Office of Financial Research are trying to gauge financial risk, if only 20% of the contract's terms are computable and 80% are non-computable, how useful is that to you? I don't know. Yeah.
Hey, Aaron Wright from Cardozo. I love the stack analogy. At Open Law, we've been building out a similar stack, but it's a little bit inverted, and I thought I'd maybe just throw that out there for contemplation. So I think actually the API or the application layer should sit on the top. So a lot of those issues that we talked about, making a human readable agreement, dealing with notifications, dealing with other applications, those really can get handled if the API sits on the top. So then that leads to a second question, what do you build underneath it? Well, I think the first thing is and this is an open question, you know, are we going to work off of what we have today, or are we going to build everything from scratch? I think that working off what we have today makes sense. So we need to liberate all these agreements which are trapped in Microsoft Word, maybe some in WordPerfect, and their XML, you know, the butchered XML version that they mark up those documents in. So at the bottom of our stack, we have just a legal markdown, just pulling out the raw text so that you have something to work with. And then from there, I think it can branch, right? You either have a markup language or a scripting language, and nobody knows what the right answer is right now, but I think that those are two possible solutions, maybe some combination of the two. And then I think to go to Daz's point, you want to have a common repository where it doesn't need to be a blockchain could provide a good solution for that, but you need to have some sort of common data structure to manage the output of the marked up or scripted contract, all or in part. And as part of that, if you are going to use a blockchain, you're the execution layer, it's just built in, right? So particularly on Ethereum, you have the data storage aspect of a blockchain, but you also have the Ethereum virtual machine, which can do some of the execution components to it. And then that can all reduce down to an API, and then you can build this whole ecosystem of apps on top of it. So I know that we're going to do a survey of what's out there, but that's the way we've been kind of approaching it, all separable open source layers, but it builds up from what we have today to what we can build in the future.
Great. Well, fortunately, I wrote the stack in a program where I can easily rearrange the ovals. So.
We have about 5 folks lined up for questions, and we've got you in the queue. Yes, sir.
If you look at what's been standardized in finance, they haven't come up with computable contracts. What they've standardized are contract terms, and they standardize contract terms in the form of messaging languages. And the reason why they did this is that 25 years ago, the volume of transactions overwhelmed the ability of manual processes to clear and settle. In order to get to automated clearing and settlement, you had to standardize the terms of the contract so that when you engaged in an agreement, you knew, in fact, what you were agreeing to. But they never made the leap from there to standardizing the contract terms themselves, which is really quite extraordinary because financial contracts are unique in the business world. Most contracts involve the exchange of money for some good or service. And it's a one-time payment, or in supplier arrangements, it's multiple, but it's multiple deliveries, multiple payments. But in the world of finance, there are no goods traded. They're just agreements to exchange cash flows. And those agreements to exchange cash flow in the entire business world are the ones that are most amenable to representation in mathematics, because that's what they are. And the amazing thing is that financial contracts are still written in natural language, And to understand what the terms mean, you have to interpret the natural language. It's like a medieval guild. You know, if you're in the guild, you know what an annuity is, you know, and you know what compounding is, you know what day count method is. And the trick is to create the computable contract, and that has not been done in finance, actually, until the Actus project put together, in fact, an algorithmic data standard that does exactly that. And it fits exactly in this discussion we're holding, the way you've described it. There are some things in a financial contract that are easily turned into code, cash flow, payment obligations. All the legal issues around it that are the protections and the what ifs, et cetera, are far less amenable to turning into computer code. And so clearly what we want to do is we want to improve the efficiency of the system by turning into code what you can put into code and make computable, and reduce the subset of things that you know, are not in code and in fact will remain outside of code for some time. Last point goes to the issue of bespoke contracts. In a world of computable contracts, code is law. If you don't have standardized contracts, you have chaos. I mean, the Dow is the best example of it. What you want is, you want people to enter into a contract with the confidence that they enter into a natural language contract that's been carefully reviewed by the legal teams on both sides. And you only get that with a validated, tested, verified, algorithmic software standard.
Great, thank you.
So we have 1, 2, 3 more, and I'm going to remind folks, I was asked when I came into this conversation to remind folks that although there's a lot of folks in this room who talk about contracts in fintech, we are looking a layer above. So I hope we can abstract beyond just contracts into all kinds of law. Yes, sir.
Actually, let me give a little bit, I'm taking a different take here, path. I work in the electronic health records, so which are very similar issues involved in there, and actually they're being implemented, and already $34 billion have been spent by the federal government in giving out the incentives for doctors using electronic health records. And you probably know, almost every one of you probably go to a doctor who uses an electronic health record. The issue is the following. It's a very similar thing. First, you have the user interfaces. The doctor has to input into this EHR, which is the electronic health record is the one which keeps track of your health from your birth to death, which is approximately 70 years. So there are 80 years maybe. So there's some issues involved. Yeah, it depends, okay. You'll live longer. So then the issues involved in there are, first you have to store. That means you have to have an appropriate representations and persistency, because this particular information has to last for so many years, so it has to be persistent. And you all know that the things that you use to store information 5 years ago, they no longer exist. In fact, most of these Macs don't even have CD-ROMs and things like that. So it's all going to be cloud-based, and all kinds of things are happening. And actually, you pointed at a very important point. When you are actually storing information, you need terminology involved in there. The terminology becomes extremely important in all these things. Then you got to manipulate the whole thing. So you got to search, you mine, you create knowledge, and those kinds of things. Again, terminology plays a role. And then finally, you have these things on exchanging information. You have to exchange that particular information which the doctor put in the electronic health record to some of the physicians out there. And again, you have syntactic and semantic interoperability. Your contracts, you have the syntactic or your XML-based, whatever you are talking about, is actually syntactic interoperability. You have to have semantic interoperability. For that, you need meaning. And all this has to be done in the context of security, privacy, trust, and those kinds of things you just mentioned. So finally, what I would like to summarize here is it depends on the intent of your contract. What is the intent here? Your intent is to share? Your intent is for someone to interpret that? Or what is the intent? Okay.
Right, thank you.
Thanks.
Jeanette.
I'd like to remind everyone that there's been an ongoing conversation in law about how to simplify the law and how to make it more accessible to human beings. And I think it's paralleling some of what we're talking about here about creating software or creating an LSP here. So how can we bring that law into computation might be eased a great deal if we simplify how it is we speak of things within the law. And you referred to a guild earlier and a bunch of terminology that only certain people understand. We need to simplify the law in some way to make it computable. And then my second question actually is for you, Harry. Who does what at the various points in your stack? Where do the lawyers construct a contract? Are they the ones that are learning a coding language and doing an API? Or have we created in our LSP something that lawyers can't use? And I would actually urge lawyers to learn to use the LSP, because what we end up with is a technological due process problem where developers are writing code that doesn't accurately represent the law.
Yes, that's a great point. And first of all, I'd like to commend you on framing humans on the one side and lawyers on the other. So, but I think this is all open to suggestion. My vision is that for these type of contracts, lawyers will be largely out of the loop once they've sort of created the template. The lawyers will be involved with the programmers in creating a template, and then, you know, ordinary human beings will use these the way we purchase something on Amazon. You know, I want this, it's this much, here are the terms that I want. You do it through your computer screen. That gets captured, and it pops up on some other non-lawyer's screen who can agree with it, and then that can be translated to some human readable form if need be. That's sort of the way what I was thinking, but I think there are, you know, other ways this could go.
We have 3 people in the queue right now, but I also, as promised, want to give a chance for anybody who's online to speak up. Do you have anything that's come in through our chat? Okay, why don't we go ahead and take those two comments right now, and then we'll come back to the folks who are online in the room.
All right, so the first question is from Krishna. She says, we seem to be talking a lot about blockchain, but any idea on the Internet of Things? A lot of execution of contracts is likely to be from that, the Internet of Things.
Yeah, that's a great point. I think that should just be part of our discussion. I was just talking about this, the extent to which laws can be embedded in things. So self-driving cars, we're starting to see the driving laws being embedded in the technology. So that's something to talk about. That has to be part of the conversation.
Great. Do we have another?
Yeah, we have one more. It says, companies such as LegalZoom must be using template-based contract approaches already. The question is, do we know how they've organized themselves? They could provide clues to this puzzle of coverage of computable contracts.
I think it's a really good point, actually.
Yes.
Yep.
On that one, it's not just LegalZoom. There are a number of folks out there, whether it's in the nonprofit world like A to J from Cali or Neurologic and people like that. A lot of those companies have, with expert systems, have broken out a lot of the logic of law. But what they haven't done is taken that next step and made it computable. So the LegalZoom has a wonderful front end, and the back end is a piece of paper. And so what we're suggesting is that what you really need is to take that front end kind of breakdown of questions, and then marry it to a back end that actually is executable. And that's the step that's still missing.
So I'm going to circle back to the stack concept and offer a suggestion. In OASIS, which is an information standards body, what you've defined is a reference model. And if you look at the definition, it's exactly what you talked about. It's basically an abstract framework for understanding significant relationships between entities in some environment for the development of consistent standards or specifications supporting that environment without being specifying implementation. So what you've got is a reference model. We have a very similar reference model in telecom for managing systems. So agree, just we'll get it defined. And the problem with the stack concept is people jump to software. Reference models are more generic, and the layers, that's key, but it's not the only piece to that model.
Great. Friendly amendment accepted. I like reference model. I think it's less confusing.
Yes, sir.
So I think this is a great discussion. We should draw on other standards bodies like Mary Beth was talking about. I mean, I have history with the OpenGIS Consortium and how they started to develop interoperable mapping protocols that we all use as Google Maps today. What they basically encountered in the first instance was cartographers saying, you mean other people could make maps? And how outrageous that was. Well, we could imagine lawyers fuming if we don't train them. We also have to train the judges. This can't just be like patent law or bankruptcy law, where only a small handful of judges understand how to enforce this kind of contract. And I also want to echo the point that was made about persistence. I mean, as somebody who looks at how we're going to do a contract for lunar water to be delivered in 2025, I can't step through the Computer History Museum of software to figure out whether the water should be delivered. There is a project, I think it's out of the United Nations, looking at capturing archival software from around the world because of the different standards that were used in government contracts. And so I think we have to have some persistence, attention, as well as training of enforcers of the contract.
Yeah, that's a great point.
Okay, well, my comment is about, well, it's related, when do we take lawyers in the stack? So where are the position of lawyers? So if we consider a contract, then what about computational contracts? What's the legal validity of computational contracts? Now, if we just look at contract law, there might be different theories, but at least one of the common principles is that a contract should be understandable by the parties involved. And essentially what we have here, that, well, lawyers can understand contracts, but if lawyers do the job properly, humans cannot understand them. On the other side, programmers can program, but very typically, lawyers, or just say the public, it's not really able to understand a program. It's too complicated for them to understand. So what will be the right trade-off? What will be languages, what will be standards, what will be protocols to write computational contracts that are both legally valid, can be understood by, let's say, legal professionals, judges, if they have to solve a conflict, lawyers, and then essentially the users of the contract themselves.
Yeah, great point.
Great. Monica.
This whole conversation makes me think of what Mary Beth had mentioned earlier, which is who is the community of interest? And I think we've been looking a lot at the level of the individual or even an individual firm at the start of a contract. And Harry had a slide earlier about, I don't know, 2 or 3 slides before the end. And I actually think that there was a little box at the bottom called compliance. And I would like to give a plug for actually starting with compliance as a potentially highly likely place that large firms who spend billions of dollars a year, for example, in the pharma industry or in the financial industry, that's where you have these repeatable kind of non-unique challenges, but they're complicated and very cumbersome and costly to manage. And it seems to me that's a more likely place to see this sort of thing start from the bottom up, and then we may well get to the point where an individual contract is going to be written in code, but maybe it's upside down, in other words.
Great. I want to remind the folks who are online that we'll give them one more chance to come in a few minutes if anybody else on there wants to go.
Just real quickly, thank you. That's a great point. So one of the things I want to plant in all of your head is we're looking for good use cases like compliance or any other contractual scenarios that people think are particularly amenable to this area. We're taking any and all suggestions, and I appreciate that.
Yes, ma'am.
Yeah, actually, I'd like to start off with a little bit of a question or survey. I'm curious who here have heard of object capabilities? Is that a framework that's, okay. So I asked that because we if we want to focus on the higher level here, our startup is actually working on a couple of open source projects, one of them being a split chain that enables a smart contract being split into human readable and machine readable and only get executed when both of them are met. But other project is that we're working on making private smart contracts interoperable by leveraging object capabilities, which to kind of like weave in what Desa was saying about what is sacred here that might be shared by both the legal realm and also the computational science realm is actually the concept of object. So with that, also what our colleague here also mentioned that barrier instrument is kind of like a way you can think of what object capabilities paradigm enable you to do. So if we focus on what is the sacred object and then enable people to grant rights to another person to access that, we are basically looking at an extremely modular system as a way to even spin up blockchain, but starting with a building frame of a private smart contracts. So I'm curious to explore this with anyone who is interested. Yeah.
Yeah.
1, 2, 3.
Sorry. So my question was actually that's a really good point, Vienna, because I was wondering, you can essentially look at contracts in two ways. One is which is the sort of the principle of contract law to view the whole contract as one object, right? So you need to interpret the contract as a whole. But then you also have multiple objects, which are the terms as Alan mentioned within the contract. I think in this exercise, I mean, it's a question for the group. How do you balance these two things, right? Because by focusing on the terms and making the terms the object, you can make the contract more interoperable with other systems like ODR, right? You're just resolving disputes for certain objects that you're disputing, but not the entire contract. So supply chain would be an example. But you need to keep in mind that you're looking at the whole contract in the analysis. So how are you going to design the protocol to balance both aspects of the contracts?
Yeah, this is a great point, and it kind of harkens back to some of the problems. Do we componentize contracts to what's computable and other parts that are not computable? I think a related problem, which I'll throw out there, is all legal contracts exist in a universe of contract law, common law, contract law, that sort of implicitly comes along with every contract. Do we care about that? Do we need to formally represent it, or do we just sort of not worry about it? I mean, that's just a question for the community I'll throw out there.
Yeah, I have no doubt that the capability to develop frameworks for making contracts computable, identifying information rules, the technical solutions in the lab, these things will definitely happen. They're already happening in AI systems and predictive analytics where it's not deterministic or legally binding. I think the bigger high-level issue around this entire initiative is not a technical one. I think it's actually one that is one of acceptance amongst sovereign jurisdictions, because agreements are legal agreements. They're not technical transmissions of radio frequencies. And I think that one of the bigger challenges in general is going to be how, if you want to establish standards, how do you get those standards adopted, mutually recognizable, within the same jurisdiction or cross-jurisdiction between parties who actually have to both agree to the actual more complex instrument as opposed to simply a peer-to-peer exchange of an object on blockchain for a token, which is a relatively simple matter.
Yeah, that's a good point. And I will throw out this idea that has been referenced. There are similar things today, internet purchases and basic financial securities contracts that happen or accepted by our legal system today. So.
Right, but if you're composing something,
yeah.
you want a system to compose contracts as opposed to use existing that are in the e-commerce sphere.
Yeah. Okay. Yeah. It's something to think about. What the meaningful difference would be there.
So what's exciting is that there's so much conversation to be had. I have about 4 people lined up. I've seen about 4 other hands. We're looking at lunch. So I'm going to get to as many as we can, but I'm going to encourage folks to keep this conversation going if I don't get to you, and I apologize.
And we will have time in the afternoon.
And we will have more time in the afternoon. Yes, sir.
I think it's important to draw on domain-independent standards for knowledge and data. And at some point, we're going to have to get pretty specific. But the good news is a lot of those are in place. So RDF and XML, OWL for basic terminology of a logical kind as opposed to natural language terminology, rule interchange format and RuleML for rules of very general kinds. Those seem to me to be good standards to build on. And then define what are the aspects that are more specific to legal that go beyond that. And so I think their good stuff to draw on includes Legal RuleML and Legal XML, which have been tackling that for a while, including meta models about legal documents, including obviously contracts. So I think it's important not just to sort of say semi-platitudinous stuff about, oh, we won't commit to, you know, proprietary or, you know, any one technology or whatever. I think it's important to start getting specific about which standards are you going to select as building blocks to build our stuff on top of. I think that's going to be pretty important to get practical. In terms of use cases, I think a cool, low-hanging, relatively simple one are usage licenses. You know, when you agree to use some system or some software, this becomes very important in the cloud era among businesses, not just for individuals. And so you want those templatized, parameterized, be able to analyze what are the key provisions instead of this thing where, you know, you're supposed to wade through, you know, pages and pages of legalese before you do something that should take, you know, 1 minute. Without it, you could spend half an hour. So that's huge transaction costs right now, and also huge non-rule of law, because people are basically agreeing to things that they haven't read in those circumstances. So I think that would be a cool use case.
Great.
Thanks.
If I could respond just very briefly to that. As we revealed to ourselves when we set up the automata representation, a part of what you see, a lot of the complexity is in the switch yard, in the non-compliant switch yard. And that's a hard thing to come to grips with. We need to come to grips with it better. But at least some of that is what you do about when the things go wrong, and that's when the complexity multiplies, and that's when you've got to have lawyers to help you probably to do it.
So I want to bring a slightly different perspective to this conversation. It's a very rich conversation in technology, but I do think one thing that I'm concerned about the direction of our conversation is we're not talking about business value. Now, I'll give my perspective. I was a GM and leader at Rocket Lawyer, so very familiar with the contracts that we were building there. And also, now I'm product leader and over at SAP, and we build pretty complex accounting and systems, which has some similarities to what we're trying to build here. So if we think about Rocket Lawyer or LegalZoom, we're talking about basically a corpus of significant amounts of contracts in the order of millions that we're creating in the course of a year. And when we were building these things, we then determined what is the business value of us actually creating logic in our contracts, the if-then scenarios, which are much more simplistic than what we're talking about here. But that's driven by business value. If you do not have business value, you don't have people actually buying it, let alone accepting it, then what's the point? And so I think in our discussions, I encourage you, and I know there are other people who are much more accomplished than me here, who are product leaders that think about business value of why are we doing what we do here? Because we can talk about the technology and the stacks, but if no one's going to use it and we're not going to apply dollars and cents behind it, like the gentleman behind me had noted, there's serious dollars in the area that he's actually applying. Billions of dollars of people actually trying to transact using the computable contract sort of analogy. If we don't talk about that, then there's no point. We've failed a fundamental mission of our discussion in the course of the 2 days. So I think that's one key point about the business value. The second key point I want to point out is that we should also think about if we're trying to do this in isolated cases, there's one approach as a product leader, as you know, is to create a very compelling use case. And I think you actually mentioned the computable contracts is a great use case. Go out there and start small and try to prove that out as something that's compelling. Or secondly, work closely with a Rocket Lawyer or a LegalZoom and avail of all of the contracts and the knowledge that they've actually had to figure out what is the right use case and what have they thought about? Why have they not done this? Because they're the ones who are best situated to actually be creating these computable contracts. So anyway, so that's my pitch for the business case versus the technical case.
It's a good point.
Do we have anybody else online? Let's have our one comment online, and we'll take this last question, and I apologize in advance to everybody else we didn't get to. I'm sorry. But we do want to make sure this day moves on.
So this is a comment from Musab. I think the project should also go beyond executability of legal terms, although that's important, to formal specification of legislations, conformance checking, and even synthesis of financial products that satisfy certain properties. Having the LSP lay mathematically well-founded methods and tools would be of great impact.
Great, thanks. I mean, I think that is ultimately somewhere this project might want to go, but we're starting small, but we're trying to lay the foundation possibly to get there, if that's possible.
Great.
Just a couple of quick comments. Business value is important, but a lot of what we're doing with computational law is also about social value, making law accessible to people that don't have any money, and there isn't going to be any money exchanged. So we have to keep that in mind as well. But to the point about semantic and syntactical interoperability, syntactical interoperability is very well understood, and there's a lot of stuff that's already going to get us there. Semantic interoperability is orders of magnitude more difficult. We're going to end up either explicitly or implicitly creating an ontology, and we need to think about that.
Yeah, that's a good point.
Does anybody else have, I know we've shut a lot of folks down, but I've lost my people. Maybe we do have time for one more. Why don't we pass this microphone back, because this gentleman was waiting for us.
I just noted it down for the afternoon, but so, so I have three short comments. First, I would like to reiterate and align with Alain here that finance does not have computable contracts so far, so we should not give them credit for that if it's actually not true. Second thing, in the two use cases that we have in the GovTech space running at the European Commission with Henning here as well, is the business value in our use cases is very simple. We reduce compliance cost. I mean, we want to slash actually compliance cost to a small fraction of where they are. That's the business value of our use cases. And the third thing is related to that. I like the point to start in compliance, and this is actually where we start as well. So we start with a compliance that is in legislation, a requirement that is in legislation, and I like the NASA example. So in the NASA example, what it also makes me think of, we do actually backward engineering and forward engineering, because for the current intensive, so I think in CodeX, we have to do where the companies currently work, so the forward, but for the future standard we do backward. Mm-hmm. But what it also made me think of is the NASA experiment is a fully controlled environment, yeah? It's a government who flew to the moon. It's not a private company. So we also started in this fully controlled, regulated environment where we can actually do things. We don't yet have to talk to everybody. And later on, we will go into areas where we have to care about consumer rights, data protection, and so on. So I think this is also what the NASA analogy can be used for.
Great. Get right behind you, and we'll let Gaza take the last one.
I'd just like to offer, from listening pretty closely to everyone that spoke, here's one suggestion for a possible use case or scenario to anchor progress on rapid prototyping, something like what Oliver's challenging us to do. And it would be, first of all, to constrain the environment of contracts to a business environment. It's because there's so many contracts and so many parties and transactions and so many forms. So if we said, well, we're looking, and I noticed you had federal government people, we have people from SAP. So if we start there and think B2B, I'm going to suggest one way to, I'm not even going to say which use case, but here, these would be the characteristics and 3 or 4 examples. One where it's there's an existing systemic electronic business processes occurring, such as with finance and ISDA, SAP and procurement, payment networks, other types of service or identity federations. And one of the things they all have in common is there's a master agreement on the top, and I've just stripped mine ISDA. It's yet another master agreement for this area. There's participation agreements, so you know every type of person. I'm a trader, or I'm an issuing bank, an acquiring bank, I'm a seller, I'm a buyer, I'm a transaction processor. I'm a card holder. And then there's individual transactions running through the network. It's a 3-layer stack if you want to look at it legally that way. And it's possible to then, if one of those was selected, even from one that ideally people are expert in the room, so that we can then push against something and then begin to have success metrics, performance or outcomes and legal predictable results, that type of thing, transaction functional kind of tests, so that we can begin to rapid prototype and see, can we find some area where there's a pain point or some new value that would really be enabled if we had this type of standardization in a context. So I would recommend a context that would be a B2B context, and one where there's a master agreement, participation agreements, and a high volume of transactions pumping through the system.
Great. I'm going to let Harry give one last word, and then I'm going to turn it over to Oliver for the real last word.
Yeah, so thank you for all those comments. Like I said, this is just a conversation starter, so any and all amendments and suggestions are welcome, so I thank you for your comments.
And before we break for lunch, I just wanted to alert people that we have inadvertently become much more transparent in that the sign-up pieces have gone out via some Twitter feeds and things like that. That is, we designed this as an invitation workshop partly because we were just not wanting to be overwhelmed with the organization. There are dozens of other people who could be here profitably, but there we are. Some of those dozens may show up. I just want people to be aware that the feed is more generalized. That meets some of Mary Beth's criteria, which is terrific, but it was not in the initial design. People should be aware of it at the moment.